Good morning, everybody. Can everybody hear me pretty well? Great. I'm going to start. We're expecting a few more people, but I'm going to start in the interest of time. So welcome. My name is Rachel Bronstein. I am the managing policy attorney at Her Justice. And I've been at the organization about 8 years, and I was a law firm fellow years before that for a couple years. So I've been close to this organization for a long time, and I'm really excited to welcome you into the Her Justice family. Just so I know who's in the audience, can you raise your hand if you're a summer associate? Awesome. Okay, and I think, is anyone an associate? Great. Okay, and then we've got a bunch of Her Justice folks over here who can introduce themselves to you during the break. And I think so that we can get to the meat of our presentation once a couple more folks have a chance to join if they're going to. I'm going to start by showing you a video that we recently made about Her Justice and the clients we serve and the law firms we partner with to give you a little feel for what we're all about. So let me start with that, and then we'll talk about child support and spousal support.
He threw me across the couch. He ended up choking me and putting me against the wall. And my son was sleeping in another room. I was just in shock.
At Her Justice, we stand with women living in poverty in New York City by providing them with free legal help through volunteer attorneys from all over the city who we train and mentor so that they can address the individual legal needs of our clients, but also address the systemic legal challenges in the city.
After we conduct an intake with the client and identify her legal issues, we provide immediate advice and counsel and prepare the case for placement with one of our volunteer firms. After 25 years, we've developed relationships with our firms so we know we can properly match those cases with those firms.
The lawyers who work together appreciate each other. There's an excitement, a spark when you see them together. Everyone knows what it means to provide these pro bono services here at Her Justice. And that creates a whole fabric within the entire community where there are lawyers who are bound together by the work that Her Justice does.
43% of single women living in New York City live in poverty, and divorces often leave clients economically insecure and responsible for debt.
We've had clients who have lost bank accounts, lost their homes, lost any value they might have had in their lives because their husband has been spending money without their knowledge, has racked up debt in their name that they can't afford to repay. And if we can't help them get out of those inappropriate burdens, they really are going to be left destitute in New York City.
Through Her Justice and my pro bono lawyers, I got alimony, which he never expected to pay. Getting the legal help from Her Justice has helped me tremendously. I'm trying to move forward now. Having the financial help is a big part of it. I feel like I'm a better role model for my daughter.
When you have a single mother living in poverty, facing barriers such as fear and lack of awareness of her legal rights, having a lawyer is critical in her ability to navigate the legal system. We become the tool she needs to reclaim her power and stabilize her life.
The lawyer at Her Justice gave me hope. She completely changed my life. She made me believe that my voice was important and that I had a right to stand up for myself.
Through Her Justice, our firm was able to get Amanda full custody of her 2 young children, a full 5-year stay-away order of protection for herself and her 2 sons.
I feel like I'm a better person, I'm a better mom, I'm a better woman. I feel like I won't ever allow anyone to make me feel like my voice needs to be silenced.
I was 13 years when I came here to USA. And I have 2 girls, and they means everything for me.
Gladys had been married, and the relationship had started out well and promising, but he had become violent, and the incident that culminated and had her decide to leave was that he tried to strangle her.
My lawyer in Her Justice, she changed my life. She gave me a lot of opportunities. She gave me peace in myself.
She sought out an order of protection against him, and she helped with the prosecution of that crime, and that's how she qualified for a U visa.
I feel happy. I feel very proud of myself. Her Justice helped me so much. I want to say thank you for everything. I feel free right now to make my dreams come true. My life better, not just for me, for my daughters.
After working for 25 years with women living in poverty, we understand the legal barriers they face and are developing policies to address them. This not only helps our clients, but it will benefit all New Yorkers.
I want to thank all of you who help us at Her Justice. Our clients are so grateful. They honestly tell us daily that their lives have changed because of the work that we do with them, and we couldn't do that without you.
Thank you, Her Justice. Before this, I was holding my breath and I can finally breathe. Thank you for giving me my life back.
So you've heard a bit about Her Justice and our unique model in the legal world in New York City, and it's the way that we partner with law firms like yours, and we're able to help over 4,000 women a year and their 5,000 children. And we've been doing it for 25 years, so it's pretty special for us that you're joining us. So this is just, again, a bit of an illustration about our model. So we have 13 lawyers on staff. And we've specialized in the areas, in case that didn't come through in the video, in family law and divorce law and immigration law. Last fiscal year, we worked with over 1,800 volunteers like yourselves, and we were able to serve, as you see, over 9,000 women and their children. So, you know, our key aims for the clients that we serve, who are women living in poverty in New York City, are to help them gain safety. About 80% of our clients are survivors of domestic violence, and we'll talk about that in a moment. To help them gain financial security, and that's a major goal of representing a client in a child support case, and we'll talk about that. And for many clients, they're seeking immigration status through our work and through your work with us. So in terms of who our clients are, we serve women in all 5 boroughs of New York City. We serve a mix of women in terms of demographic and racial and ethnic identity. The clients who come to us, about 2 out of every 5 need interpreting. So some of you may yourselves have language capabilities beyond English, and you may be working with a client for whom English is not her first language, which is a major service to somebody who, frankly, would be unable to access the legal system without your help. And you can see, you know, we have a majority of clients born outside of the United States. Vast majority of our clients, 73%, are mothers, and that's significant for child support. You know, just so you understand sort of our process, and Hamra Ahmed, our legal director, referred to this on the video, we at Her Justice screen clients who need help. So they're calling us on a helpline. They're coming to us at the city's family justice centers, which are walk-in centers for those who are victims of intimate partner violence. And then we're making a match, as Hamra said, with firms like you, like yours. So all clients who come to us get advice and counsel, and some we're able to make a match who need full representation to navigate the complex legal system, which we're going to talk about. And as I said earlier, 80% of our clients are survivors of domestic violence. And I'll try to note throughout this presentation where domestic violence considerations are significant in a child support case. For obvious reasons, in an order of protection case in family court, the crux of that case is that you're trying to gain safety for your client through an order of protection. But many of our clients in divorce cases, in child support and spousal support cases, are victims of intimate partner violence. And there are considerations that you'll want to keep in mind when working with a survivor. We have a sort of domestic violence 101 YouTube training at this link here, which I encourage you to watch if you're interested in the area, or especially if your client is a victim of intimate partner violence. Because of our unique model where we train and mentor attorneys like yourselves, or rising attorneys like yourselves, we have developed some best practices. There is a section of the child support manual. I don't know if everyone has received this at their firms yet, but we have a thick manual that we develop and update over the years, which goes into much greater detail about the topics I'm going to discuss today, and which I encourage you and really implore you to consult, because there's a lot of rich information in there that you'll need. And in the, I think, back of that manual, there is a best practices guide, something we developed because we know we're often working with new lawyers or students who are studying law, for whom working with a client may be a first experience, even if it's not the first time you've worked with an individual. Always good to hone those skills. And it talks about best ways to communicate with your client. Not only might this be your first time working with a client, but it might be the first time your client is working with a lawyer. I like to talk a lot about, with new clients, confidentiality, really explain what that means and why the legal ethical rules around confidentiality are designed to encourage honest communication with lawyers. That might be a first for some of your clients. And just other sort of basic things, coming to the security desk in a large law firm lobby. I mean, these are some things that might be new for your clients. So just kind of talking through some of those basics. You know, it's a very different thing. I mean, I worked in private practice. I was a law firm litigator for years, and I'm now at Her Justice for years. It's treating your client, your pro bono client, the same as you would a commercial client walking in the door here is an important thing to start practicing early in your career. So, for your own workload, we say on here managing deadlines. Now, if you're doing a child support case, you have a court date, and we're going to talk about procedure in family court in this presentation. But just for, again, early sort of skill building for yourselves is managing deadlines. I'm sure that your firms are talking about this with you in terms of your billable work, but as with your billable work, manage your pro bono deadlines. If you have a court date coming up, know that your Her Justice mentor, whose name you may or may not have gotten yet, is mentoring many other cases like yours. So better than the night before saying, I need you to review this discovery document, give some lead time, think ahead, right? We're going to talk about early development of your theory of your child support case. The earlier you can do strategy and thinking and preparation for your case, the better. But that also goes to working with your Her Justice mentor. Okay. And we encourage you to reach out to your mentor often and early. I already said read the manual. The mentors at Her Justice, I mean, we were founded by a law firm partner 25 years ago because that law firm partner, Kathy Douglas, our founder, knew that law firms have vast talent and resources, and there was great need in the community. So many of us come from the law firm world. We understand what it's like to be in that world, and we are here to support you in this kind of work that you're taking on, often for the first time. So again, read the manual, communicate over phone, over email, best to schedule phone conferences with us. These seem like small points, and I realize they are. We'll get to the meat in a moment, but these are important ways to make your experience the best that it can be, rather than worrying so much about not getting the support you need. Just be in touch with us. Okay. Before we dive into income, which is the basis for child support and spousal support calculation, let's just say why child support. And as I mentioned earlier, I'm the managing policy attorney for Her Justice. A few years ago, Her Justice began dedicating more of our time and resources to work on system change. So not only do we serve individuals in case representation, but we are working towards system change based on the needs that are exposed in our clients' cases, court reform, legislative reform. And one of the major areas that we've been working on, and specifically I've been working on, is child support. Why? Child support is about poverty, by and large. I mean, certainly wealthy families separating or divorcing are going to deal with child support if there are children of that union. But by and large in this country, child support is about poverty. For families that are receiving child support, single heads of household, usually women, child support can represent anywhere from 40 to 70% of that family's income. So that is a major piece of the income, right? So we have a complicated scheme in this country, which I will not go into detail about, but if anyone's really interested, you can always ask me, where the federal government provides welfare dollars to the states, and the states run child support programs. There are all kinds of regulatory issues around that. Administrative agencies are involved. And in New York, the courts are heavily involved in child support, which is where you will be doing your child support cases. And you'll see later when we talk about enforcement of child support, how the administrative agency is also involved. I say this because you can imagine, and I encourage you to continue to imagine as you represent your client in this child support case, how challenging it would be for her to do the case without you. 90% of people in family court cases on child support in New York City are without lawyers. 90%. Again, when we talk about the substance, remember how difficult it would be for someone who perhaps doesn't have a law degree, maybe doesn't have a college or a high school diploma, perhaps English is a second language, to navigate this extremely complex system on her own. And so we're grateful for you to be involved and to help navigate this system, which is unbelievably complex. And there are all kinds of, as you heard in our video, the threads of gender justice, economic justice, racial and ethnic justice. These are threading through child support work as well. And so just keep these in mind. And, you know, I always, just because it's my way, I always think big picture. So from one case, what does your involvement in that case mean in this system at large? Okay, so enough of my big picture stuff. So what is child support about? It is about income. I mean, simply put, it is about income. Now, families fall apart all the time, whether it's a marriage, whether it was two people who are unmarried with a child in common. Families fall apart. There are a lot of emotions that go to that, right? Many of our clients are quite emotional about suddenly being on their own or having struggled on their own for years and finally found a lawyer and an agency that can help them. But fundamentally, child support is about income. And one other quick footnote before I go on. Our clients are women. The people we serve are women or those who identify as women. The vast majority of the adverse parties in our cases are fathers, are men. By no means is the law gender slanted, right? The law is gender neutral. The law talks about parents. We have many families that are non-traditional families, same-sex couples. For ease, and it's lazy, but for ease, I'm going to talk in terms, and I'll do my best to talk in terms of custodial parent, the parent who has the child with them, frequently the mother in our cases, and the non-custodial parent, the parent who does not have the child with them the majority of the time. But if I become lazy and talk about mothers and fathers, I hope you'll forgive me, and I hope you'll know that the law is not defined in those terms. Okay, so income. You'll see from this list appearing on the screen that income is very broadly defined in the Family Court Act, or the FCA as abbreviated here. Why is it broadly defined? The law wants children to have child support for basic necessities, and we'll talk about what those necessities are. But the law defines income broadly because there's a public policy interest in as much income as the family can have going to the child being ordered by the court. So you see, W-2 tax return earnings, traditional on-the-books earnings, but also things like disability benefits or unemployment benefits or government benefits like Social Security or veterans benefits. Sometimes you see if there's an older parent, there's a pension or retirement benefits. Again, very broad definition of income that is enumerated in the Family Court Act. Frequently in our cases, we have off-the-books income. And why do I say frequently in our cases? We are motivated to get lawyers involved in the hardest cases on child support. If there are, and you'll see how this bears out in a moment, but if there are two W-2 earners, child support is simply a calculation. So, and I mean literally the court takes out a calculator and plugs in the numbers. That is a fairly easy case. For some clients who call us for help in those cases and say, I'm working as a receptionist and the non-custodial parent is working in an office of a construction company, we can give advice such that that client can go to court, not always, but often go to court with the right paperwork and get the fair order of child support. If the other parent has off-the-books income, that is much harder. You will see the burden of proof that the person seeking child support has to prove off-the-books income is challenging. Some examples of this are free rent if you're a building superintendent, right? Some perks. So let me go back. So we have cases often where the other side is a superintendent in the building, and as a perk of that job gets free rent. That's considered income for that parent. Would it be so easy to prove that in court if you were unrepresented? Probably not. We have restaurant workers. We have non-custodial parents who have their own businesses, who have that business in cash largely. And you'll see there's an obligation for both parents to disclose income, but it is not always the case that the adverse party or the non-custodial parent is free-flowing with the information about his income or her income. The law, and again, this is all enumerated in the Family Court Act, the law provides for certain deductions from income for some taxes paid. The first few categories are here, are taxes paid, or categories on a W-2. But you'll see that if there's court-ordered child support, for example, for an older child that's already being paid, that is a deduction off income, right? The idea is not to impoverish the non-custodial parent in your case, but to arrive at a fair award. Similarly, if the non-custodial parent is receiving public assistance or welfare or supplemental security income, which is a government subsidy for poor or ill people, that is a deduction from income. Frankly, if the adverse party is receiving these two lower categories of income as their sole or large percentage of their income, you're probably not looking at much child support. And we'll talk about what that looks like in a moment. There are categories of non-recurring income. There could be a life insurance policy that pays out, a loan forgiveness program that comes due. There could be an inheritance. There could be lottery winnings. The idea, again, is that income is conceived of so broadly in the law such that even one-time lump sums of money would be considered for child support. We do a lot of cases that are based on a concept called imputation of income. Now there is, just back to the big picture for a moment, there's a real policy push from the federal government and through the states and in the courts you see it, but there's a real policy push for evidence-based child support. Now, in a lot of ways I find that interesting. Again, if you're interested, we can talk offline, because child support is always evidence-based. As we have said and as we're going to continue to demonstrate here, it's based on income. And there's a formula for how to come to a child support order. But the courts, for various reasons, are very interested in getting fair child support based on someone's actual ability to pay. Imputing income comes into play when the current income of the adverse party is low or zero, let's say, perhaps because that person lost a job. And you, as the representative of the custodial parent, the mother looking for child support, are going to make an argument. He may be earning zero now, but he was earning $50,000 at the construction job he was employed at 6 months ago, and it's his own fault for getting fired from that job, and therefore the court should essentially charge him with earning $50,000 now. It's a fiction, but it's based in law, and there's ample case law to support this concept. And again, the idea is we're trying to get child support for the child. We're not trying to get the guy on the hook necessarily. She's not taking him for child support. There's a lot of rhetoric around this, but the bottom line is the courts have a public policy interest in getting the right amount of child support for a child. And if dad was earning $50,000 6 months ago and for the 4 years before that, dad can find a job at that earning level now. And so that's the idea behind imputing income. again, and if this is the theory of any of your cases, you'll discuss this at length with your mentor. There is a bit of reluctance on the court's part because the courts want to get a fair order. Nobody wants to come up with an order that is impossible to pay, and we're going to talk about that in a moment. But there are various interesting ways to litigate a case where that's the theory around labor statistics. Plumbers, we had a case recently, plumbers in New York City earn, I don't know, what, $45,000, $50,000 a year. And that is based on a statistical analysis of the average income of workers in that field. You can bring that evidence in, really interesting. Or there's not so much statistical information about the particular field that the non-custodial parent has been employed in. So perhaps you say, well, interestingly, dad has a new BMW, dad just was in the Caribbean, or dad, you know, the lifestyle suggests that dad has the ability to pay more than he's claiming he does in this litigation. So this can be a really interesting place for litigation. And again, we're screening cases so that we are looking for hard ones like these that would be very difficult for someone without an attorney to put on to the court. So as a last resort, the needs of the child form the basis for the argument around child support. So again, each parent is, and we're going to talk about the vehicle for this, but each parent has an obligation to disclose their income. In the absence of, and this is what the statute says, in the absence of information or evidence of income, the court must consider the needs of the child. And now we're looking at basic necessities: food, housing, clothing. What are the basic needs of this child? And we'll talk about in a moment how your client will prove that. And this might be also the situation if the father defaults altogether. There are some cases where, despite having been properly served with papers and notified of the action pending, the non-custodial parent doesn't show up. And so with one or two chances for dad to show up, the court might come to this analysis. And your client's testimony and evidence will be what forms the basis for the order. Now, what's tricky about this is something I said a moment earlier, which is that sometimes the order comes to an amount that is not possible for dad to pay. If dad doesn't have a history of earning, you know, again, child support is often about poverty, and not only mom's poverty, but often poverty on the side of the non-custodial parent. If dad doesn't have an earnings history that allows him to pay $500 a month, if that's what the court comes to, then you could be, or your client likely, could be in the territory of enforcing that order or trying to chase down that order in the future, and we'll talk about that. But again, this is statutorily provided for as the last resort where income information is unavailable. Okay, one thing to note. I keep saying both parties have an obligation to provide proof of income. We'll see why that is the case, but it is the case that your client will provide proof to the court in the form of what's called a financial disclosure affidavit. And we'll talk about that in more detail in a moment. The reason for that is that the court is going to fix what's called pro rata shares. We'll talk about it, of certain expenses, unreimbursed medical expenses, out-of-pocket child care expenses. So your client's income comes into that calculation, and we'll see it in a moment. A note about ethical considerations. Some of our clients work off the books. Some of our clients are undocumented immigrants. Or some of our clients work off the books because those are the jobs available to them. There is often a question from lawyers and clients, what about the tax consequences? Is the IRS going to find out if my client provides on her financial disclosure affidavit that she earns $400 a week at a restaurant for off the books? The answer is no. We have an obligation in this proceeding to provide proof of her income, as does the other side. So while you can be cognizant of the ethical considerations there, it's not an ethical prohibition for you to provide proof of off-the-books income from your client. Maybe she babysits for the neighborhood kids, whatever it may be. And we can talk more about that with your mentors in particular cases. Sometimes the immigration considerations are for the non-custodial parent. maybe he's an undocumented immigrant, and maybe he's a busboy in a restaurant or whatever it is. And for that reason, and with increased ICE enforcement or immigration enforcement in the last couple of years, and in some cases in the civil courts, like child support court, there could be real fear that is motivating either parent to hold close that information about how they're earning money. Again, the court is not going to call the IRS or call immigration, but you may see this as a thread in your cases, and we should talk about it. You should talk about it with your mentors as it comes up. The burden of proof, as I mentioned, is on your client if she is seeking child support for the first time in an initial order or an establishment order. We'll talk about violations and what the burden of proof is there in a little bit. Even though both parents have a responsibility to prove income, sometimes information is not free-flowing from the adverse party. It is important when you first meet with your client to talk to her about what does she know about his earnings currently and what does she know about his earnings in the past. She might not know much. This is another area where domestic violence can kind of come up. Many of our clients are victims, as we discussed, and for many of them, what that looks like is isolation around finances. These two could have been together for 10 years, but she might have no idea what he earns now or what he's even earned when they were living together. That is not uncommon. It is not a credibility issue for your client. It is often a function of the abuse. Abuse looks like control and power first and foremost, even if it doesn't look like physical or emotional abuse. It looks very frequently like control and power, and control can often be exercised over finances. So she might have never seen a bank account. She might have been prevented from working outside the home herself. She might have no idea what kind of work he does or have a vague idea, but have never seen financial papers. That is not uncommon. Do not feel as though she is hiding information from you or that she is trying to hide from the court. It's very common, and it just might mean that she is not the best source for you as to his earnings history, and that's okay. And we'll talk in discovery about what you can do to elicit information that might not be coming from him so readily. You may have a modification case. Just by a show of hands, has anyone or everyone seen their case file? I don't know where we are. Yes? Some people? Okay. So a modification case is a case where there's an order from the past, and one of the two parents is seeking to change it. She might be seeking an increase. He might be seeking a decrease. The party seeking the change has the burden to prove that there has been a change in circumstances since the last order. For obvious reasons, if the order was issued a month ago, it's pretty tricky to come and say back to court, hey, in the last month there was a major change. Maybe there is. Maybe he happened to lose his job the week after the child support court entered that last order. I might be skeptical of the reasons for that, but modification requires a showing of a change in circumstances since the last order. So again, if he's saying, I'm unemployed now, you're asking why. If he's saying his boss decreased his hours, you're still asking why. You're sort of probing into what the reasons for the change are, and we'll talk about that. I'm watching my time. Okay. So let's look at the calculation, which I keep referring to, and I have not shown you yet. So one note is that child support in New York, and this is by state. So for example, recently we're looking at North Carolina in another case, and child support in North Carolina goes to the age of 18. In New York, it goes to the age of 21. So you could have a kid in college and child support obligation still exists. Here are the three components of a child support calculation. The basic child support obligation, which is money from the non-custodial parent to the custodial parent. There are mandatory add-ons and there are discretionary add-ons. We'll get to the add-ons in a moment, but here is what the beginning consideration of the calculation of basic child support looks like. It starts with the number of children. If there is one child, you are looking at 17% of parental income, and then it goes up from there. So if you have 6 kids, you're looking still at 35% of parental income. And may I note that there is an error on this slide. See that asterisk up to a combined income of $143,000? There is an indexed cap for child support. What that means is every couple of years, this number changes. It's now 148. It is the income combined of the parents under which this calculation I'm about to show you applies. There are some rare cases where the adverse party earns $200,000 and income above the cap at the time, $148,000 now, the court can discretionarily order child support on that above the cap income. Most of our cases are under that cap because of the demographic of the clients we serve and the demographic of the non-custodial parent. So you're starting with the percentage of income based on the number of children. This is a written out version of a formula that looks like this, which I'd rather show you here. But basically what you're looking at first is what is each party's income, step one. In this example, dad earns $75,000, mom earns $25,000. Step two, combine. What is the combined parental income? Here it's $100,000. And this is annual income. The step three is this pro rata share. And again, this, keep in mind, is for those add-ons. That's what is important, why your client's income is important for these add-ons, which we'll get to in a moment. So in this calculation, mom's income is $25,000, which, because we gave you easy numbers here, is 25% of the combined parental income of $100,000. And dad's is $75,000, which is 75%. Right? So here, let's go back. So they're pro rata percentages. Mom's is a quarter, dad's is 3/4, okay? Now, in step four, you're going to calculate the total child support obligation for this child per year. There's one child, the combined parental income is $100,000, so 17% of $100,000 is $17,000 per year. That is the money that should flow to that child per year. Because mom is the custodial parent, she's not going to pay anyone that money. It's the non-custodial parent whose share we need to understand here. That's step five. So in step five, dad's pro rata share is 75% times the total obligation of $17,000. His share is $12,750. That is the basic child support amount. The first of the three components of child support that we saw a couple of slides ago. So that is the amount that he's going to pay her per year for this child's support. For month, and this, the court will calculate this, the monthly versus biweekly versus weekly, frequently on the basis of how dad gets paid at work. If he has 26 payments a year for a biweekly check, the court's going to divide that annual amount of $12,750 by 26. Does that all sound okay? The mandatory add-ons that I mentioned earlier are these two: work or school-related child care expenses and unreimbursed health expenses. Unreimbursed health expenses are co-pays, premiums for health insurance. The court has to determine which of the parents is going to provide health care. Many of our clients receive Medicaid for their child or public health care. And if dad does not have employer-sponsored health insurance, the child will continue to be on Medicaid. But if dad does have employer-sponsored health insurance through his job, that is where the child's health insurance should come from. You might see that when you ask your client, do you pay copays? Do you pay for doctor's visits? Do you pay for prescriptions? If the child's on Medicaid, the answer is usually no. The answer is usually she does not have out-of-pocket costs, and that is what it is. But if there's private health insurance through an employer, there may well be, as many of you know from your own experiences. And the pro rata share, in our example we did before, if there is an annual premium, let's say, for private insurance of, I'm making this up, $2,000, dad is going to pay 75% of that on our example earlier, and mom's going to pay 25% of that. So this is where this pro rata share, and your client may say to you, but why do you need to know my income? And this is where it comes into play, is to figure out what relative portion of these expenses each party is paying for. Just one point. Sometimes it is the case that because our clients are living in poverty, they're not able right now to pay for childcare, which means they can't work. So you can see a cycle developing for many of our clients. They cannot find a job because if they find a job, they have no childcare and they can't start paying childcare until they have the job, right? So discuss with your mentor, but there are many creative ways to represent on a financial disclosure affidavit, which is the document where you provide your client's income, your client's expenses, and including things like childcare. And the other side does it as well. The non-custodial parent does as well. There are creative ways. For example, what I often do is put an asterisk and say at the bottom, client or deponent, petitioner anticipates spending $300 a week on childcare. And the anticipates is that you should be able to, your client should be able to, in the litigation, say to the court under oath, I've researched the daycare options in my neighborhood. My understanding is that it's going to cost $300. So there can be anticipatory expenses. I mean, it's a little bit of it convincing for the court, but you can prove that to the court that once she begins working, which let's say she's hit the pavement looking for a job, once she begins one of those jobs, she's going to have this in childcare costs. I mean, these are the ways really that child support is an anti-poverty measure, right? I mean, this is really what it gets down to, is sort of figuring out the way for everybody to do their thing, work, childcare, the kid goes to school, so that they are thriving as a family. Okay, there's the third category, which is discretionary add-ons, and these are add-ons for the court in its discretion. So these are provided by statute, but not mandatory as part of the child support calculation. And these are things like childcare expenses for seeking work. Now, in my example I just gave you, that anticipatory, you're going to try to convince the court, right? You may also be trying to convince the court that your client is so busy looking for a job that she needs child support now to pay for daycare, right? So it's not just that when she begins working, but maybe you're going to try to convince the court she's hitting the pavement and needs the child care covered or contributed to by dad now. Similarly, private school, college tuition, special ed, after-school summer expenses. I've been on sort of a kick to argue that after-school and summer expenses are childcare. It's discretionary, but in my own family, I certainly view that as childcare, and I think that it's fair for you to make that argument to the court that the summer camp program at the local school is going to cost this much money, and the child's going to be there so that the parents can work. So I think that is a strong argument to make, and I've seen it succeed. The private school thing, and you see that sometimes with clients, where they've agreed as a family when they were a family unit that the child was going to go to parochial school, let's say, and the non-custodial parent was paying a portion of that. If you can sort of demonstrate to the court that that was an agreed-upon decision between the two of them, then the court may well continue, sort of for the sake of the child's stability, to obligate the two parents to share pro rata that private school, parochial school tuition. This is an example of an order, just so that you see it. You should see here some important things. At the top of the page, the courthouse. In this case, it's in New York County, which is Manhattan. The caption, she's the petitioner, he's the respondent. In this example, it's an order modifying an order of support. You'll see, and I want to just put a pin in this for later, the file number and the docket number. Those are important numbers because there is a court website called eCourts, the link to which is in our manual for sure, but also you can Google it, where you can use those numbers for your case to see upcoming court appearances. And we'll talk about that in a moment. You see there's an obligation summary here, basic payment by David Jones, biweekly amount. SCU is the support collection unit, which is the agency that I mentioned earlier This is the enforcement part of child support, right? The courts often make the order and the agency enforces it and collects it. And then here's a child care biweekly cost. And you can just see here that she filed a petition on February 7th. In this case, she was seeking to modify, as we talked about, an earlier order, and that's the child's name and date of birth and social. So just to give you a feel for what this all looks like, I'm just going to read a code for the folks who are viewing this on video, a CLE code, and that is THX3G7. Again, that's THX3G7. And we're going to go for about 10 more minutes just so that you all know, and then we're going to take a break. Okay. And how am I doing? Yeah, I'm doing fine. Okay. So just a note about deviation. So the statute, the Family Court Act, enumerates various reasons that the court can, in its discretion, deviate from the CSSA, Child Support Standards Act. That is the act that sets out the calculation of child support. Why would the court deviate? There are poverty levels that are set that are relevant here. One is the federal poverty level, just for context, for a family of one, or a single person. The federal poverty level is about $12,000 right now, and that's set every couple of years, or annually, actually. There's also something in the state law called the self-support reserve, also a number that changes every year or so. It is currently about $15,000 a year. It is the amount that the court or that the law sets as a floor for under which it would be impossible to support oneself. The idea being in child support that if the CSSA calculation that we looked at before comes out to a number deducted from dad's income that puts him or the non-custodial parent below the self-support reserve or the federal poverty line, there are flat minimum amounts of child support that kick in. Specifically, if it would mean dad's income is below the federal poverty line, child support will only be set at $25 a month, regardless of the number of children. So in other words, if you have 5 kids and that child support number would bring the non-custodial parent to $10,000 a year in income, child support will be set at $25 a month for mom, period. For the self-support reserve, if the amount of child support under the calculation would bring his income below around $15,000, the order will be set at $50 a month, regardless of the number of children. The idea just being that, as I said earlier, poverty issues surround child support for both parents. It's not designed to impoverish the non-custodial parent either. And then there are various, what the court calls unjust or inappropriate factors. If there are special needs of the child, if there are non-monetary contributions by the non-custodial parent, the court might take those into consideration and deviate or decrease the CSSA calculation of child support. If there are non-subject children, let's say living with dad, who are not the child or children of this couple that you're litigating with, the court might consider those. If there are extraordinary visitation expenses, let's say dad lives 5 hours away in upstate New York and mom's here in the city, and dad pays $200 a month for the bus back and forth to see the child, the court might consider those and give dad a break on the child support calculation. So if there are factors like this, you may raise them on behalf of your client, or the other side might raise them on the non-custodial side. Okay. I think it's probably best in the interest of time to save questions till later, and I'm happy to answer them. So let me move forward to spousal support. I'll just say briefly, spousal support, there are very different policy considerations around spousal support. It is what it sounds like. It is support from one spouse to another. So these are married parties. I don't know if anyone in this room, do you know if you have a spousal support case? Does anyone have, because you could have okay. Do you have straight spousal support or a combination? Okay. Sometimes clients who are married will file both for child support and spousal support in the same petition in the family court, but sometimes they'll just file for spousal support. So you have married parties, and the obligation is from one to the other. A lot of interesting history here. Her Justice was part of a coalition that advocated for successfully about, I don't know, was it 5 years ago now or so, for a change in the spousal support laws so that it was more standardized, like child support with a calculation. And in a nutshell, these are the two schemes of calculating child support. I won't read all of this out loud as you see it on your slide. What the basis for spousal support is a significant enough discrepancy between the two parties' earnings. In other words, if you have two parties earning $25,000 a year, your calculation is not going to give spousal support to one or the other. Or even if you have someone earning $30,000 versus $25,000 for the other, there's really not enough, and if you did the numbers, you would see enough of a discrepancy such that the higher earning spouse should pay spousal support to the lower earning spouse. Spousal support is really about sort of getting that lower earner spouse to a point of self-support. So, which is why it's sort of contingent upon a significant enough discrepancy. And there are two calculations in the law. One where there are children, like you're seeing on the screen right now, where the payor is also the non-custodial parent. And the other where there are no children, or the payor is the custodial parent. Let's say that is the higher earning spouse. And again, the idea is to take into account the child support and spousal support, or maintenance, they call it also, combination. And just so you know, spousal support or maintenance is a tax deduction for the person who pays it. It comes off, in other words, if I earn $50,000 a year, but I pay $10,000 to my spouse in spousal support per year, that gets deducted from my income for purposes of taxes and added to the recipient spouse's income. So in the combination case where you have spousal support or maintenance and child support, you do the maintenance first because of that income switch, and then you do the child support, just so you all know. There is an online calculator for spousal support, and you see this as a divorce link here. The reason is that many times maintenance, it's called in divorce cases, which is the same as spousal support in non-divorce cases, is done in a divorce. If for some reason in your case, where you have married parties, there's a discussion about divorce, or the other side files for divorce, absolutely discuss that with your mentor. We, as many things have in New York, have a complicated scheme of family court handling child support, orders of protection, custody cases, spousal support between married parties, but the Supreme Court handling divorce cases. So there is a forum difference here, which becomes very complicated if in the middle of your spousal support case, the other side files for divorce. So I won't go into those details now, but know that it becomes an issue in some cases. And like child support, there are deviations. Self-support reserve, I've discussed. If maintenance or spousal support is going to impoverish the payor, there's a floor to that. There's similarly an income cap that is raised or indexed by statute every couple of years. That is the cap up to which income between the parties is subject to that maintenance calculation we just talked about. Again, unjust or inappropriate factors. You can argue for a deviation up or down from what that calculation comes out to be. And if there is no income available, then you're arguing things like we talked about earlier, lifestyle. He seems to be living the high life. There should be money available for spousal support to my client. You are also arguing things like the standard of living during the marriage. The parties had a home. It was his fault that it got foreclosed on, but there were indications that they lived a life such that the fruits of this marriage, the economic fruits of this marriage, she should be receiving some spousal support for some amount of time. And just interestingly, because of this forum difference I mentioned, where family court handles spousal support between married persons and the divorce court, Supreme Court, is handling those issues, the family court should not ever put an end date on spousal support because it is not empowered in terms of jurisdiction to end that marriage. So we've gotten into some really interesting, and we appealed a case involving this, where the family court put a limit, a durational limit on the spousal support, which is wrong because its jurisdiction doesn't extend to ending that marriage. Only the Supreme Court's does. So if you have a spousal support order, it should not have an end date. So that's just an interesting point. So we are right on time for a 10-minute break, and then we'll get into family court procedure and how to litigate these cases. Thanks. And if you have questions, feel free to come to me. Hey, everybody, we're going to start again so that we can get out in time. And I just want to make absolutely clear that in every one of the cases that you're handling, you will have a Her Justice mentor. So if you don't know who that is, you can ask the pro bono coordinator or counsel at your firm, or you can ask, we might know. But just to make that clear, that I know I'm giving you tons of information about the law and litigation, et cetera, but you will have a Her Justice mentor who's an expert in this subject area. And you should also absolutely, and as we move momentarily into procedure around family court, you should absolutely rely on the litigators at your firm, whether it's a partner or associates, to provide guidance on basic litigation tools. I mean, we're also experts in that area, but you're at top shops to get mentoring internally on how to litigate cases. Because things like the CPLR and the rules of evidence govern in family court as they do in any civil litigation. Just one note, a last note on modification and termination of spousal support cases. I just wanted to say that as with a modification of child support, if your client is seeking a change in spousal support or the other side is seeking a change, the change in circumstances standard applies. And as I said earlier, if there's the death of the parties or I didn't say that earlier, but the death of the parties would terminate a spousal support order because that obligation is no longer. And a judgment of divorce, as I mentioned, would also end a spousal support obligation. So let's look at family court procedure. Many of your clients have already done this step one, which is to file and serve the petition. So the petition is what governs in family court as a complaint does in Supreme Court in a divorce or in a commercial case in the commercial part. This is the pleading, the initial pleading. So many of your clients, I think most of your clients, if not all, have done this. And so it's an important document to have. We have collected it for you from your clients in our screening process. And a couple of notes, the venue, the county in which your client is filed is usually where the client and child or children live, unless there's some safety reason to file in a different county because her address is confidential, which you would know, I think, from the file. You would just want to make sure that all of the children are included in this petition. I mean, again, as I said earlier, 90% of parents in family court child support cases are doing this alone. What this looks like literally is that they walk into family court and a clerk sits across the desk from them and helps them prepare this computer-generated petition. How good that communication is depends on many factors, as you can imagine: language, nerves, et cetera. There could be a huge line of people waiting. So just check this. Is the date of birth wrong? Is the child missing? Whatever. Just check that document. And I think it's almost always the case that the client has served the petition on the adverse party, but you want to make sure. And if there's a question about that, talk with your mentor about the service rules related to this. Now, many of you then will know when your first appearance is in the case. The family court schedules appearances under terminology that might be unfamiliar. The first time the case is on in family court, is scheduled to be heard in family court, is called the return of process date. That is the date when everyone shows up, and it is the return of the service of process proof, essentially. In other words, if everyone shows up, there's no question that the adverse party was notified of this case pending because that person is there. If there's your client but no adverse party, and there's any question about service, that will come up in that court appearance. And there might be an adjournment or a postponement. There's a lot of sort of inside baseball language in family court, but an adjournment means a postponement of the court case until another date for various reasons, but including if there's a service issue because dad didn't show up, we don't know if he received adequate notice. Again, I think probably service issues are not going to come up in your cases, but if they do, let's discuss them. So what you can do with that petition is go onto this eCourts website, and you can Google it, or there's a link in the address is in the manual, and it shows upcoming court appearances. Unfortunately, it doesn't provide past litigation activity in a particular case. It's just not what the family court provides, but that file number can be used, and you'll see on the site, the file number can be used so that you can confirm, I'm going to Queens Family Court on June 20th. This is the jurist presiding. Note about jurists. The judge or the jurist in a child support court proceeding is called a support magistrate. These are specialized appointed jurists, lawyers, to preside over child support cases in particular. Okay, so you'll most likely be appearing in front of a support magistrate. So you are going to want to review your file, the documents that we've provided. You're going to want to schedule a client interview. And, client interviews, as I said way earlier on, are about discussing logistics, what it's like to work with a lawyer, confidentiality, where's my, how to come in and out of my office, but also things like building rapport, right? Again, this might be the first time she's worked with an attorney, so you're going to want to build an open communication with her. And then you're going to want to do some sort of housekeeping documents, her proof of income. You're going to see probably in your file birth certificates for the children. Is there information about her health insurance? Does she have a card that provides information? If she has bills that are the basis for your request in the litigation to get contributions from the non-custodial parent for health care expenses, does she have copies of those bills? Records. You're going to want to identify what are the issues in this case, what are the records you need to support that. So you might not get it all in the first meeting. You probably won't. But on the phone in advance and then in the meeting, you're going to want to be making sure that you have the documents you need. And the idea there is that you're going to be preparing the financial disclosure affidavit, which I wish we had a copy of, which we don't. Note for the future. You can Google that as well, and there's also a copy in our manual. It is the financial disclosure affidavit. It's basically an assets and liabilities statement, like an expense statement. It's expenses of all types, income of all types, liabilities, credit card debt. So it's a very extensive form, 8 or 10 pages. It is likely the case that your clients won't fill out all of the stuff. Again, some of our clients live a financial life that is not very involved with banking and other companies. It's, a simple, I babysit for the neighborhood kids and these are my this is my income and these are my expenses. It is not easy to estimate expenses. I don't think it would be easy for me to estimate my expenses. So be patient. It is a work in progress often over a couple of calls or meetings. But what you kind of want to do with that financial disclosure affidavit is like what we call the smell test. Like, does it really make sense when you add up those numbers for your client and her income, her expenses exceed her income by $2,000 a month? Is that the reality? It might be, because she might be borrowing money from family and friends to make up the gap. But in the way that the court will be skeptical of any evidence that comes before it, you want to kind of put that to the test beforehand in the pleasant setting of your own office with the client. You kind of want to be saying, you know what, this doesn't really add up. Can we go through that again? Do you really spend $200 on the movies each month? And maybe she does. It's not a judgment on your end. It's we want to put your best, most credible evidence before the court. Let's test it now. So that's what you're thinking as you're collecting information. You'll be bringing that financial disclosure affidavit to the first appearance or the return date, as I mentioned, establishing service, providing your client's financial disclosure affidavit, and proof of income. Again, this is enumerated in the statute and also in our manual. The court has an obligation under the law to establish a temporary order at that first appearance. I don't know statistically, but anecdotally, I know that it doesn't always happen, even though the court is statutorily obligated to do so. And why doesn't it always happen? Because proof of income on the other side is often poor or non-existent, or the non-custodial parent doesn't show up. And so you will argue for, and you'll prep with your mentor in advance, you'll argue for a temporary order based on your well-prepared financial disclosure affidavit and your client's evidence, if any, or information about the kind of earnings that the father has, let's say. But you may not get a temporary order. Push for it. Just do your best. And again, prep with your mentor. The spousal support is not, the court's not mandated to provide a spousal support temporary order. It's sort of a different public policy bent on getting money to kids quick. So you see this last point says the father may appoint a lawyer. I don't know if anyone has a violation case. Do you know if you have an enforcement violation case? I don't know. Those are cases where, and it's important for me to say this even if no one in the audience has that kind of a case, because it gives you a sense of the full life of child support in a family's life. Very often is the case, after your great work securing an order of child support or spousal support, there's a point later in time where that order is not paid on by the adverse party. Circumstances change, a job is lost, or there's a willful failure to pay. That is the basis for your client to go back to court and file a violation enforcement case. And this is the rare exception to where, to the general rule, which is that there is no right to an attorney in child support cases if you're poor. If it is a violation case, the respondent, the person who should be paying but is not, is entitled to a court-appointed lawyer. And the reason is that one of the remedies the court has in an enforcement case is incarceration for failure to pay child support for up to 6 months. Because of that liberty interest at stake, the law provides that dad or the respondent, the payor, the would-be payor, is entitled to a court-appointed lawyer if that person can't afford to pay for one. So if it is a violation case, at that return date, the court will say, do you want an attorney to dad, and are you financially eligible? What do you earn? Okay, I'm going to get a court-appointed attorney for you. You might also see, though, in a non-violation case, an establishment case, a modification case, that the court says to dad, as the court would if you weren't standing there, to mom, are you hoping to get an attorney? And the court might adjourn the case one more time, postpone it one more time, so that dad can try to get an attorney from a legal services agency, or if he can afford one, retain private counsel. Okay, so much of the case, like any civil litigation, you'll see, so one of the beauties of doing these cases as private practice attorneys is that the litigation is just like any case. I found that when I did this work for clients directly, the stages of litigation were like any: pleadings, discovery, motion practice, settlement, or trial. It's the same as any other case. So much of the case is about gathering evidence. And so I mentioned you're going to ask your client questions about what she knows and what she has in terms of documents. There is going to be an effort, of course, to get information from the father or the non-custodial parent, and possibly from third parties. So all of the discovery tools that would be available in any civil case are available here. So you might have, I don't know if you've taken civil procedure in first-year law, but requests for documents, interrogatories, subpoenas are available to you. So you may well decide that if dad, and this is not necessarily something you might, but not necessarily something you would decide minute one, or even at that first court appearance, maybe strategize with your mentor and your in-house folks. But you may well decide that if dad is not forthcoming with information as the case unfolds, that you need to serve some discovery requests to drive the information gathering process. There's a slight complication, which is that a family court proceeding is considered under the CPLR a special proceeding, which means that you must ask court permission to do discovery. Because as much as I've said the rules of evidence apply, the CPLR, the civil practice rules apply, and that is true, there's a bit of a Wild West in family court. So there's also sometimes where that is to your advantage. In this instance, what I mean by that is you don't usually have to make a written motion to get discovery, like to be permitted to then ask for discovery. You can usually say to the court, Your Honor, this is a case where dad has a cash business. He's not forthcoming with information about that cash business. The taxes he filed last year show $7,000 in income, but we know he has an SUV and he goes to whatever country on vacation. So we're asking the court orally for permission to do discovery in this case. That usually flies, usually. Rarely is it required that you do a motion in writing to get permission. So just to sort of put that out there. It is sometimes the case that it's useful to subpoena third parties. Do you want to subpoena his bank records because your client's telling you that every month he sends $600 to another country where, let's say, his country of origin or a family overseas or whatever it is, and he's not forthcoming with that information, but you know that without that extra $600 a month, his income or his savings are artificially decreased. So might you want to do a subpoena on the bank? Yeah. Talk about it with your mentor and also talk about it in-house. And I say that because your firm may have conflicts with a bank that is being represented by your firm in a commercial matter. We're in New York City. A lot of these firms represent banks. So do think that through and talk it through with your firm before you blanket New York City banks with subpoenas. Okay. It is often the case, this is my refrain, that the other side will be unrepresented because 90% of parents are unrepresented in child support cases. That may mean that, giving the benefit of the doubt, your excellently drafted interrogatories, requests for documents, are unanswered because dad doesn't understand a 20-page document where you've asked all these questions, which are legitimate questions, but a pro se litigant may be unprepared to answer that. It might also be that the other side is obfuscating. So there could be a lot of motivations for this, but the fact of the matter is you may not get the discovery you want. And it is sometimes the case that, and this is down the road, right? This is probably back when you're in school next year that this is happening, or maybe if you're lucky, the following year when you rejoin the firm. But it may be the case that you and your firm decide to do a motion to compel dad to answer interrogatories or discovery requests, and in the absence of providing those answers, that he is precluded from testifying favorably in his case, in his defense. That can be really powerful if you convince the court to do that. What it means is that your client's story goes, and that's really, really powerful. So these are, again, things, I'm giving you all the context, even if you're here for a summer and not for the long haul. But it's important to be thinking in advance. Again, what is your theory of the case? If you have a cash business on the other side, you may well be teeing all of these things up for your colleagues to be dealing with down the road. And that's really important to do that well. So don't think that it's your tiny piece of the puzzle now. You're setting it up for the future. And a motion to quash, if there's a subpoena that you issue, let's say, we've seen this sometimes where there's a third party. Let's say dad is married to somebody else and that new spouse is providing or is covering all of the expenses in the family. You may do a third party subpoena, a subpoena on her or him for information about their earnings, saying that's the source of income in this family that's letting dad not spend on this child. We have survived some motions to quash the subpoena, to end that subpoena, because it's with arguments that it's really relevant. But it's also not a fishing expedition, right? It's not that you should practice every single CPLR skill you've learned. These should be tailored to the needs of the case, and you should be checking in with your theory of the case to warrant the use of all these things. Okay, so like any civil case, or like the majority of civil cases, many can settle. There are very strict rules around settlement of child support cases because of the overwhelming public policy of child support being done right for the sake of the child. So the court will approve any written settlement where it has statutory language, and this is in the weeds to be discussed with your mentors if you get there, but the court requires that a child support settlement agreement has language about what the child support calculation would be and why it is an agreement of the parties to deviate up or down from that. So there are cases where the parties say, and sometimes in the case of a litigated divorce, you might see this, where there are other issues going on and you're sort of offsetting child support against something else. You can easily say, with a lot of the right language, which Her Justice can supply in examples, we see that the child support calculation would be $500 a month, but because dad has agreed, and the parties have agreed, that every summer dad will take the child to Croatia, which at his own expense for 3 weeks of the summer, saving the family on summer camp expenses in New York, we're going to agree that that amount should be less of child support, something like that. So it can be done, and families often do it. But it does require some special language just to be aware. And as with any decision to settlement, client's decision only. With your guidance and your advice, but her decision how to resolve the case. That's just an important ethical consideration to keep in mind. And the other thing that I didn't mention about stipulations is that you should set out, and again, this is statutory, but you should set out the standard for future modification of the agreement. There's a statute that says if the party's income changes by more than 15%, the child support can be modified. As with other aspects of child support, the parties can agree that that standard does not apply and that they take a different route for how to modify this agreement in the future. But do know that the standard for modifying an agreement is higher than modifying a court order in the past, right? The idea is if you've agreed here, we're going to hold you to that agreement and make it even harder for you to prove that there was an unforeseeable change in circumstances that justifies changing this agreement, right? And it makes sense. Okay, trial. If anyone's lucky enough to get to trial, I think you'll have fun. A lot of prep goes into trial. You'd want to update, as you have a continuing obligation to do as things change in litigation, the client's financial disclosure affidavit. You're going to want to, of course, ensure that you've comply with all discovery requests. And as I said, evidence rules apply. I'm not going to teach you a course on evidence right now, but your Her Justice mentor would absolutely support you were you to go to trial, as would litigators at your firm. But you're going to ensure that documents are authenticated, that you have the right foundation. And then it's really a matter of preparing your client's testimony and preparing her for cross-examination. Credibility is chief, right? That is a major part. I think in some other cases it's even more important, for example, a custody case, where there's less document-heavy evidence. But in a child support case, credibility is important. What is the story about her working off the books for many years? If her testimony about her work history is the best evidence there is rather than a lengthy history of documentation of her earnings, that testimony has to be good, has to be sound, right? So you're balancing, what's my best evidence, testimony, or do I have documents to back it up? And that's the case in child support. Again, what's your theory of the case? Is this a case about a cash business? Is this a case about a lifestyle that suggests ability to pay that is more than what's being disclosed to the court? So that's threading through your preparation for trial. As with any civil case, the person petitioning the court, or the plaintiff, let's say, in other civil cases, goes first, and then the respondent. Direct is as it would be in any other case. Open-ended questions that you're asking. Telling the story of this family's financial life together. And then going through the financial disclosure affidavit that your client has produced and documents to support that. And the cross-examination is like it is in any other case. You're asking questions to which you know the answer, right? That's the golden rule of cross. Don't ask the question, so how is it that you can afford that BMW? If you don't know the answer to that, don't ask it. Because maybe he'll say, well, it's not actually a new car. I'm borrowing it. Who knows what the response would be, and that is not an effective question in cross-examination. But is it the case to say, well, isn't it the case that you purchased this vehicle for which we, bless you, for which we have a registration last year, and you've parked it at your sister's house and you're pretending you don't own it? We, by the way, have amazing partners in many of the financial services firms that are in this city, who, in the right cases, will do really fantastic work surveilling businesses. I mean, we had a case, which we always refer to because it was a fun one, where the adverse party, the father, owned a laundromat and was something like claiming $7,000 of income a year, which was impossible because it was a long-term business he had, and it just didn't make any sense given lifestyle and other evidence. So we had a financial services firm stake out the laundromat and watch the number of customers, and they then testified as experts at the trial. And we've had many other examples like that. They can analyze business records that are cash business, that dad's the proprietor of a business. Really amazing support that in the right case, they're willing to offer your firm. So it can be really a lot of fun. And you've got a pro se adversary, which is often the case. The court may also drive that testimony, will ask questions, and might even jump in on your own testimony of your client and ask some questions. The courts, these are high volume courts. The courts are moving these cases along, so do not be offended. This is part of litigation. Also, don't be offended if the court yells at you, because that's, they always say you're not a lawyer if the court hasn't yelled at you. But the court is trying to move these cases along. I think you'd be, I hope, saddened to hear that, some of these cases get like an hour of trial. I mean, they don't, they might get an hour here and then like 2 months later another hour. There's not a lot of court time dedicated to these cases, and those first appearances, those return dates, can be like 5 minutes in front of the court. A lot of waiting time and like 5 minutes in front of the court. So, it's a high volume system with, frankly, a lot of trouble around airtime in front of the court. Do you get enough time? I'll mention actually now, why not, that we've been doing for about a year and a half a court watching project, and it's a project that focuses on going into the child support courts throughout the city and having summer associates, law firm lawyers, other professionals, other students observe child support proceedings and report back to us on a tool we developed, observations of fairness. How much time did the parties get? Did they get a chance to ask questions? Did the magistrate explain technical terms? And we're doing an analysis to really push the envelope on access to justice issues in child support in particular and in family court in general. And I'm doing a couple of trainings if anyone's interested in getting into court before their child support hearing or appearance. You might want to come and you can talk to me afterwards about the details. But just to say, even with a trial, you don't get days on end as you might in federal court to put on your information. Okay. I mentioned earlier that, before I get to that, let me read the code for the video. Okay. The CLE code is AJ5M as in Mary, R8. Again, AJ5M as in Mary, R8. Let me take a sip of this. So, collection. Really interesting area of child support law, I think. You saw earlier in this presentation, SCU is highly recommended. And SCU is the Support Collection Unit. It is an agency that will collect from the payor or the non-custodial parent and provide to the custodial parent. It's administrative, so it happens outside of the court. And we recommend it because SCU has enforcement powers and can keep track of arrears, which are amounts owed that are past due. And just in general, to keep an accounting of amounts paid. They can garnish wages. If the non-custodial parent is a W-2 wage earner, SCU can set up garnishment of the wages, so it's an easier collection, and then remit it to your client. Where there's domestic violence, this is another reason that SCU collection is recommended, rather than allowing the power and control history between these two parties to be a reason that dad doesn't regularly provide payments to mom. So there are lots of good reasons to have SCU involved. I will say, because it's an administrative agency, it can be clunky. There can be a delay with getting, especially a temporary order or even a final order, payments mechanized through SCU, so be patient. And you can talk with your mentor about the mechanics of how to get SCU involved. Often your client has to establish an account with SCU. But they can do a lot of things to enforce. They're statutorily empowered to enforce child support payments, so they can garnish or intercept is the right word, tax refunds. If there's an amount owed that has not been paid and dad receives a refund, SCU can take it and give it to mom. They can even suspend a driving license, which you wouldn't want to argue for if dad is a truck driver. But if it's something, a thumb on the scale that might convince dad, get that child support going, then you can ask and advocate with SCU, and we can talk about that, or your mentor can, to suspend a license or a passport. And you'll see, just a note, that SCU is available to enforce child and spousal support together or child support alone, not just spousal support. Again, they're most interested in getting money to children. The really interesting violation and enforcement scheme in New York, which is actually currently the subject of a class action suit that Orrick is lead counsel on, which is very interesting. We can talk about that at another point. But the courts were delaying in enforcement of child support cases, which they are, under the third bullet here, required to do it in an expedited manner. And there's a class action suit against them with some Her Justice clients as plaintiffs or petitioners. But the idea here is that if your client has unpaid support, she can petition in family court for enforcement of that. And just to mention a shifting burden of proof, and these themes, I think, go back to what we discussed earlier. This is an area where the courts are especially interested in ability to pay for the respondent or the non-custodial parent. The idea being that if your client sues in family court for violation, she has to show that the other side, non-custodial parent, had notice of the order and didn't pay. And that establishes a willful failure to pay. You knew and you didn't pay. The burden shifts then to the adversary or to the respondent to say, well, I couldn't pay. I'm unable to pay. And this is where ability to pay and evidence comes in. And then your client is making a lot of arguments like, well, he says he lost a job, but he's been employed at an earnings of $50,000 for 5 years, and I don't see any evidence from him that he's trying to get a job. And so frequently the court will require that non-custodial parent to come back with proof of efforts to find a job. Often a job diary. I went to this website on this day, I went to this shop on this day, and really show an effort to find a job. I mean, you can understand, especially post-economic crash, there were a lot of considerations that were beyond the walls of the courthouse in how folks were getting jobs, how easily they were getting jobs. But this is the kind of argumentation that you'd be making in an enforcement case. Just to say, as I said earlier, we are asking for law firms like yours to help on the hard cases. So we're not usually going to ask for help on behalf of a client where there's no chance of recovering money. I mean, we see sad cases where there are $60,000 in arrears because it hasn't been paid for 10 years. And mom's been struggling to support those kids on her own for 10 years. If we think that there's really a low likelihood that she'd recover, even with various remedies available under the statute here, that's probably not a case where we would ask for help. But there are amazing victories by this law firm where we are and your law firms to recover money where mom has struggled for years to pay for all the child's needs, and dad has obfuscated or just willfully failed to pay. Amazing victories. These can be really meaningful cases for people who feel that the system honestly has not supported them, right? That they got this order, but it had no teeth. And now, with these various remedies, there really can be money that comes to the family. The money judgment is a judgment the court enters in one of these violation cases that is for the arrears owed, and it is 9% statutory interest. So it is a huge penalty against dad or the non-custodial parent. And, you know, of course, that looks good on paper, but it also depends on ability to execute on that money judgment. It makes the mom, let's say, a creditor of dad. So in other words, if he then goes to buy property in Pennsylvania, she's going to get paid first. Or if he goes to pay off an auto loan, she's going to get paid first. So it is really important, even if current ability to execute against property that dad owns is uncertain. It is really important. And I mentioned before, and this is very controversial, I think, in a lot of ways, incarceration is a remedy, which means that the court, and we're in civil world here. This is a civil contempt statute. That's why incarceration is available. We're not in the criminal world. But for failure to comply with a court order, civil contempt allows incarceration of up to 6 months. And the courts are, for good reason, reluctant to do this. Nobody wants more folks in jail. I mean, we can talk at some other point about the policy implications and for the demographic whose lives we're involved with here of over-incarceration. Nobody wants that. It can be an effective threat in some cases. And many times what the court will do, and they're not threatening this off the bat, right? They're looking to see, is dad employed? Can he be employed? Can he find a job? But many times what the court will say is, okay, we've been litigating this enforcement case for a year and a half. If you don't come back with $3,000, $5,000, some discretionary number, which is called a purge amount, that goes towards satisfying the arrears that are owed, then you're going to be sentenced, or, put in jail. And there are creative solutions, weekend jail time, so that dad can work during the weeks. Sometimes our clients say to us, I want him in jail. I've been struggling for 10 years, to support the kids. And that really is a conversation. I mean, someone who's in jail can't work. And it's a consideration. There's also an immigration concern there. If dad's undocumented, this could be a reason for deportation, failure to pay child support, and incarceration for that reason. So it really is a holistic discussion that should be taken seriously. And I know it is by the courts and by our attorneys and by you. So think it through. But, the point is failure to pay child support is very, very serious. And therefore, the court has pretty broad and serious powers. Okay, so I'm ending early. I don't know how this is possible, but here we go. May I just talk for a moment about next steps? And then what maybe we'll spend a few minutes doing is answering questions, because I'd love to hear a little bit more of a discussion, or allow for a discussion, which I know I haven't done. So if you don't have your case yet, speak to your in-house pro bono counsel or your pro bono partner. Review the case file. Ask questions of it. Ask questions of her justice about what information is missing, what you don't understand. Set up a conference call with your mentor, and if you don't know who your mentor is, again, ask internally, and start talking about what's the theory of this case, what are we after here? And then you're going to set up your first meeting with your client and talk to your firm about the protocol per the firm's rules about those first meetings. There's going to be a retainer agreement, an attorney-client contract. That is something that your firm will handle, but you should be talking to them about it. You will want to give them, I presume, because I think everyone in New York State does this, a copy of the client's rights and responsibilities, which kind of sets out what are their rights, what are their responsibilities, how to work with a lawyer. So these are some things that should come from your firm and not from her justice. But just to say, as I've said many times, talk to us early, often. That is how you will get the most out of your experience, how we will be able to provide the best support that we can, and know that you are making a difference in somebody's life by even having a lawyer at all, and by what will most likely be wonderful victories that you get for this client. It's an incredible experience. I know for me, I was a summer associate many years ago, just like you, and it, look where we are. It formed, it was what motivated my career. So it's an exciting opportunity, and we are grateful for your support. Please tell me what questions you have. Oh, thank you. Thank you. Yes. Oh, wait, Natalie's going to, our wonderful legal assistant, Natalie, is going to run around with a microphone, or walk around with a microphone.
Thanks.
Tell me what firm you're from.
Gump. If mom gets into a new relationship or new marriage, is that income from her partner calculated at all in any of this?
For child support?
Yeah.
It can be. It can be. That would be an argument, though, that you would wait for the other side to make. And that it would sort of be the argument that you'd make against, let's say, dad, if there were a lifestyle that suggested there needed to be less support to the child. But you don't need to disclose unless you're in some special situation where the lifestyle is very high. You don't need to disclose husband's earnings necessarily as contributing. But what you do need to do really carefully, though, is then think about how her income is meeting her expenses, right? I think that's a bit of a fact-specific question, and that financial disclosure affidavit would need to look a certain way if, for example, you wouldn't say if they're renting a $2,000 apartment because there's extra money in the house, you wouldn't sort of decrease mom's income by the full amount of that $2,000 income, or rent rather, right? Like that wouldn't be a fair portrayal of what her financial experience is. Do you have that in your case? Okay, just a question. Okay. But that's a good question. I think it's fact specific, but I do think it's mindful to a fair presentation of her income versus expenses if there are other people in the household covering some of those expenses. I don't know if any of the other attorneys would disagree in here, but do you disagree? No, I would. Yeah, okay. Okay. Other questions? Yes.
How do student loans fit into the definition of income? Because I saw fellowships was on the list, but that seems like more like a scholarship, basically, as opposed to like loan money that's attributed for a specific purpose.
That's a good question. I think, but Caroline, tell me if you disagree, I don't think it would be considered income. Like, in other words, if they're getting their room and board paid or by loans, I think the loan is offset by the liability. So it's a zero. Do you agree? Okay. This is Caroline Davis, by the way, one of our new experienced family mat attorneys. So I think that's right. I think that's right. What else? Anyone have questions based on their actual case that would be interesting to others without disclosing clients' names and specific information that would be confidential? You can be general about it.
What if these are loans that they're paying off? Is this just an expense or?
If they're paying off loans of any sort, credit card debt, student debt, I mean, I think that would be a fair reduction on their income, right? So their income would be offset by loans that they're paying off. Yeah, I think so.
So this is a pretty specific question, but as far as proving the non-custodial parent's income, what do you do if it's not just off the books, but is, comes from illegal sources or isn't regular or, you have no idea who to subpoena for it, et cetera?
Yeah, I mean, it's not that rare of a situation for us. I mean, the illegal income is, I think, fairly rare for us, although just to be clear, illegal, like drug sale proceeds are considered income if you can prove them for purposes of child support. So it's, as you say exactly, the question of proof. So I would imagine, in my experience, it's been the case that the non-custodial parent is not going to be so forthcoming with illegal proceeds, illegal sale proceeds, let's say, or even things like, I mean, a little slightly more innocuous, but still illegal, like an apartment in the basement of that person's house that they illegally rent out, right? I mean, that's like a little less morally tricky than drug sales, but it's still, not something they're going to be willing to disclose, perhaps. And then you're in that tricky realm of how good is your client's knowledge Is it firsthand? How sort of substantiated can that be? And then, I'm asking questions in a set of interrogatories there. And I'm really, maybe I'm not saying, I'm asking questions about all categories of income. And if the answer is no to categories that we believe there are, then I'm also probing lifestyle, right? Like if there's more income than meets the eye because I see that the lifestyle looks pretty good, you're sort of hitting that. So your approach is going to be broad at that point. And that is often the case. I mean, a lot of people don't live organized financial lives. And it doesn't necessarily matter what socioeconomic class you are. But people don't live organized financial lives. And so it is often the case that you're relying on clients in firsthand or good knowledge and a set of interrogatories. And if those aren't answered, maybe you're making a motion to compel and preclude from answering favorable information like, I don't have any money. Like, no. And then you're talking lifestyle. Like, you're multi-pronged approach. And that's the beauty of representation, right? Because impossible to do without. So yeah, I don't know if that answers the question, but that is all fair game and often a robust strategy to use all of them at the same time.
Thanks.
Sure.
So this is kind of case specific, and I just want to make sure I'm understanding kind of where we are in the order of events in our case. So in our case, the client and the non-custodial parent have already been to court. There is a temporary order in place, and we have another return date in a couple of weeks. Are we still in the realm of step 3 because it was around the time of tax day and they're looking for updated filings, and then we might be moving to trial? Or is there something that I might be missing here and maybe we're about to have a rough 3 weeks?
That's a good question. Do you know if she filed a financial disclosure affidavit?
I believe that she did. I would have to triple check the
Okay.
file. I do know that they were ordered to bring in both of them were ordered to bring in their 2018 tax returns.
Okay.
And that there is a temporary order in place requiring him to pay a certain dollar amount.
Great.
So presumably some calculation has been made.
Okay, great. So if they have, or if she has provided a financial disclosure affidavit, she did it pro se. In a rare case, we might have helped with that, sort of on the back end, but probably she did a pro se. And so you want to go through that with her and amend it. I mean, you have an obligation and an opportunity to continually amend the financial disclosure affidavit, in which case you would caption it amended financial disclosure affidavit. But you should go through that with her, and it's a way to get to know her as well, to go through as you would if you're starting off fresh with a financial disclosure affidavit. But you want to go through what she put on there, and sort of test it. Like I said, does this add up? Does it make sense? Is there anything we forgot? That is a great resource you can provide at this stage. And then, so I would be appearing in 3 weeks with an updated financial disclosure affidavit, unless it's perfect as it is, but probably not, because they're hard to do. And then I would be appearing at that next one with that. And also on the way, just like everybody else, with your client thinking, is there discovery that we need to do here? I mean, is this a straight W-2 case? It's possible, by the way. I said earlier we ask for help in hard cases, and we do. But occasionally during the summer, we do ask for help in straight W-2 cases. Is it that?
He is in the gig economy.
Okay.
So we should be able to talk to the employer, but tips are involved. So
Oh yeah. Okay.
Tips should be documented. It's car service.
Yep.
So tips should be documented,
But maybe not. Exactly. Okay, great. So, so I would be revising that FDA and amending it as needed, and I would be thinking about what discovery I want to do, and at that next appearance, and again, I'm caveating this, if I'm not your mentor, which I may not be, certainly defer to your mentor strategy. One of my esteemed colleagues, it might be different, but this is what I would do. And I would be ready on that return date in 3 weeks to say to the court, this is the situation. We have a temporary order. We believe there's tip income. We want the ability to serve interrogatories or whatever else you identify as producing that information. Yeah. So the answer is yes, you're still in the early stage of this. I mean, frequently the case that first appearance, like nothing happens. Even though, as it did in your case, there's supposed to be a temporary order. But you see that it looks like he provided some proof of income, such that the court said, okay, here's a temporary order, which can always be adjusted. One thing to mention that I didn't say is that, let's say I'm making it up, let's say your temporary order is $100 a week. By the time that case is concluded in settlement or trial, discovery's gone by, there's a final order. If the order is $200 a week, whatever was paid toward the temporary order gets credited toward that. Similarly, if it's the reverse, if the temporary order was too high relative to the final order, it's credited against. So because the final order is retroactive to the date of filing. Does that make sense? So any amounts paid will be credited toward what should have been paid from date of filing to date of the final order. Credited amounts paid, and then going forward, you pay the final order. Make sense? Okay. But it can always be adjusted, and it often is adjusted. Yes?
So you mentioned that if the non-custodial parent is fired from their job because they failed to show up for work or something, you can use like projected future earnings like based on their capacity to work or jobs that they held previously. I'm curious about like what if they voluntarily left a higher paying job because they just didn't like it, or they wanted to work fewer hours, or they wanted to be an artist and freelance or something, and now they're making a significantly less income. How does that factor into?
Yeah, I mean, I would still put that in the category of voluntarily underemployed. I mean, slight caveat to the success of that argument, if he sort of had like a one-time chance at some really high-paying job, but had a much more modest earnings history before that, I could see an argument. Again, the court is trying to fix an order that will be paid. So I could see an argument from the other side, and it depends on whether that party is represented, or if they're unrepresented, how well they can do in court by themselves. I can see an argument if that was like sort of an aberrationally high earning year for them, and also with varying income. You see that sometimes where it was like a super good year, they argue, and no other year was the overtime free flowing like that, or the tip so high. That's a possibility, which is really why, I'm saying to them, show me the full thing then. For 5 years, what have your tips been? Or as many years as possible in the job, what have your tips been? And, I'm looking then I'm arguing for an average. But, the court is balancing let's charge this person who voluntarily left a decently paying job with that amount of earning because they shouldn't have left that because they have a child to support, with, if it was out of whack with prior earnings, your chance of winning the best order ever. And, I'm not encouraging people at all to argue more conservatively, but know that the goal is to get the order paid. So if this guy 1 year earned $80,000, but every other year he earned $55,000, is it reasonable? You can push for it, but is it reasonable? And you might lose. You might lose on that extra bit. Yeah. Yes.
If the parties settle, can you still bring the settlement to SCU to collect the settlement, or that's only through the court?
Yes, that's a good question. And the mechanism is that the settlement will be so ordered or signed by the court, and then in that moment, the court will order it. Your agreement could say payable through SCU, and the court will, whatever they do, to ask SCU to begin collections. So yes. And, again, there are a lot of gaps between the court and the agency. So just be patient and mindful for your client and I mean, on your temporary order, is that going through SCU? Yeah. I mean, she may say to you, I'm not getting the money. And it might be a little bit of time. It depends on how long it's been in place, but there's a lag frequently. And this is part of the sort of systems reform that we've been working on a lot, is to figure out what those gaps are, because many of our clients go back and forth between the courts and the agency. And one thing we didn't say, which I just want to, now I don't want to get late here. No, it's still 11. One thing I want to say that I didn't address, although it is absolutely relevant to the fact that you're litigating on behalf of people in poverty, is public assistance. So you may have clients, and this gets tricky and case specific and can be discussed with your mentors, but you may have clients who were recipients of cash public assistance. So public assistance is welfare. There are forms of assistance: food stamps, semi-monthly cash grants, rental assistance, Medicaid. Cash assistance and rental assistance trigger an assignment of the right to get child support to the state. Remember how I said earlier the federal government provides welfare dollars to the state. The states run a child support program, among other things. There is a recoupment scheme that the state providing welfare, specifically cash public assistance and rental assistance, but not food stamps, the state providing those forms of assistance to a family in need has the right then to go after the person who should be supporting that family, either the other parent of a child or the spouse of that client, let's say. The idea is that if the state's paying out cash, the state can recoup. It's not a one-to-one, but recoup on behalf of that family. So you may have clients, and we frequently do have clients because of financial need, are receiving welfare, cash public assistance for a period of time. And it may be that during that time, the state went after dad for child support and got an order. They went to court against dad and got an order of child support that they've either collected or tried to collect on. And now she closed that cash public assistance case. She got a job as a home health aide, for example, and now she wants to pursue support. I just want you to understand that this is a scheme and this is a part of life for many of our clients. If there are ins and outs that we should discuss in your particular case because your client says that he used to pay child support to this, I know that the state went after him and now he's paying me and I want to modify that order for myself, let's discuss in detail in your particular cases. But I do think it's important, because of all the policy implications and the reason that child support exists at all, to understand that this is a reality for the system and a reality of many of our clients' lives. And they are in and out of public assistance, support collection unit for child support, in the courts, back to modify. I mean, this is the life of a poor person, honestly, who's dealing with these things and trying to support a family. So I just wanted to mention that if it comes up. Public assistance sometimes does. Okay. Any other questions? Great. Thank you so much for your questions and your attention. I appreciate it. Thanks.